Hello, I'm Robert Allen, your MTSA Mooting Officer. In this, the second of our recorded conversations on advocacy with members of the Middle Temple, I'm honoured to be joined by Master Simon Myerson. Master Myerson was called to the bar in 1986 and later took silk in 2003. He practices criminal and regulatory work out of St Paul's Chambers in Leeds and civil law from Byrom Street Chambers in Manchester. Master Myerson also co-authors the online site Pupillage and How to Get It, where he has published several interesting blog pieces on some of those subjects we'll be addressing today. Master Myerson, first of all, thank you so much for joining me.
Thank you. Thank you for having me.
Thank you. In preparation for this discussion, I was having a look at some of those blog posts which you've put up. And it seems that you share my fascination for looking back at some of those great advocates of yesteryear. So my first question is, what do you think the modern day barrister can learn from the likes of, say, Marshall Hall or John Philpott Curran?
I think positive and negative messages. The two positive messages, I think, are to be able to command language. It's important for advocates that they express themselves clearly, and inevitably, even when you promise yourself you won't, and the judge is clearly bored by the fact that you are doing, you will make the same point twice, and sometimes three times. But at least if you can make it in slightly different language, you hold the interest. I think the second thing, which is more serious, is these are people who could chime with the tribunal they were addressing. They got results by being good at delivering not just the facts and the substantive argument, but also on expectation of what the hearer was going to get. And that's really critical to be able to read a tribunal. The negative messages, if you read them now, they are massively overblown and ridiculously emotional. But that is because fashions have changed. And nowadays, if you spoke like that, you would be in breach of my last rule. You wouldn't chime with your audience at all. They just stare at you and say, what on earth is he droning on about? Gilbert Gray, the late Gilbert Gray, who was my head of chambers when I began, got this, and he won't mind me saying so, from his place at God's right hand, badly wrong in a particular case he did in Leeds, where he, on behalf of a Jewish defendant who had become Orthodox on remand, said to the High Court judge, he isn't the first Jewish boy to be persecuted for his beliefs. And it must have sounded great in the bath, but it sounded clunkingly terrible in court, and Gilly knew it did. It was very, very rare for him to miss the target like that. And he'd got a bit carried away on this. But it's a good example of what I mean, of a phrase that might 100 years ago have elicited sympathy, merely eliciting, what the hell are you talking about?
That style has obviously died out, even if one or two times we might try and revive it for old time's sake. I know I have in the odd bit of advocacy session on the bar course. But does that mean that rhetoric is dying in court? Or is rhetoric still alive and well?
No, I think rhetoric is still alive and well, and I think the devices of classical rhetoric should be studied, because what they focus on is how to get a point across in a logical order that impacts on the mind of the listener. But you have to align it with modern behaviour, and the advocacy is far more informal now than it was even when I first began.
Yes.
So it's within a professional lifetime. And that means that it comes back to something we will touch on, I think, as we go on, which is that advocacy has to sound like you.
Yes.
And that's why simply reading out one of Cicero's great speeches doesn't work. Although actually you'd think it would, if all you were doing was delivering.
Yeah.
But that isn't what happens. So I think it's just about using the tools and adapting them to modern day behaviour and expectation.
Yes, and I think that's something which students often get wrong. We actually touched on this in the first of these recordings, about the fact that it's often, there's so much in a student's mind is worrying about coming across correctly, using the correct terms of address, you know, putting all of your points in that you're supposed to make, asking for formal citations to be dispensed with. And all of that clutter can often be a great distraction from the point that you're actually trying to make.
Right, absolutely agree. And one of the best bits of advice I was ever given as a student was get the procedure and evidence rules straight in your mind, boring and tedious though they are, because it's one less thing to think about, and you cannot afford to be an advocate whilst what's really going through your head is, am I allowed to ask this, or am I allowed to do it in this way?
Yeah, yeah.
And I'm afraid I do remember, you know, old and crusty though I am, at the beginning, this terrible sense of, am I able to do what I want to do, or is the judge going to say to me, stop there because you can't do that? And that's something that you get rid of with experience, but you can help yourself to do it.
Yes. So you've been at the bar for almost 35 years, if you don't mind me saying.
No, it constantly surprises me, but it's true.
How do you think your own style has evolved? You say at the start you worried about asking the right questions. How do you think that style's evolved in 35 years?
So I'm a lot less self-conscious. I'm a lot less prone to use the hack tricks that I started to use when I was junior. But I make the point because, bizarrely, if you put your weight behind them, they can work. For about 5 years, with witnesses who always used to say, I've got perfect recollection of this event, which was obvious nonsense, I would score points by saying, are you sure? And they'd say yes. And then about 5 minutes later, I'd say, can you just help me? What was the third question I asked you? Now, the judge is sitting there groaning, and it really is a hack trick. But as you go one-on-one with the witness, you can really unsettle somebody. Now, if I tried it now, the judge would say, Mr. Myerson, don't bully the witness. But if you are a young, keen starter out, they are less inclined to do that and more inclined to think, well, it's fair enough contest, let him give it a go.
Yeah.
So I think your style evolves to meet your own. As you age, you change. As you gain in seniority, you change. As you've been through the fire, as almost any barrister of sort of my generation has inevitably been, you alter the way you do things because you've done things before. So I think I would say now, I used to aim for keenness and terrier-like pulling and pushing and tearing of evidence apart. Now I aim for calmness and magisterial competence. I miss by miles, but at least I know what I'm aiming for.
And you say be yourself as an advocate. Would you say, we've just met, we've been talking for about 10 minutes. Would you say that you are that calmer personality. You're not the terrier-like person that you perhaps tried to portray yourself as when you first went into court, or?
No, I'd say it's the other way round.
Or is it? Okay.
I have to be held back usually. Function of a good junior, and I've been blessed with a number of very good juniors, is to say, in the words of Sergeant Wilson, "Do you think that's wise, sir?" But taking silk, and I'm sure I'm not going to be the only person who says this, has a huge impact, I think, because you move from, I have been qualified and I am competent to do the job and they are going to listen to me, or he or she is going to listen to me if I earn it, to this sudden realization that there is a weight of expectation on you because somebody has said they're good enough for the front row. And I think if you'd have said that to me the week I took silk, I'd have said, what on earth are you talking about? But you suddenly find that judges who before that might have thought, oh, well, I'm not sure, suddenly think, well, or seem to be thinking, well, he's in the front row, so I'm going to treat it seriously.
Yes.
And I think for most of us, that imposes an additional responsibility.
Yes.
You know, you're careful about how you behave and you're careful about what you do. And silks particularly, but senior people generally, should not be trying, as it were, to gain the court's attention or get the upper hand over a witness simply by force of not personality, that's fine, but behavior that isn't necessary for them to establish themselves, and at that level comes across as oppressive. I think you could use, you know, you could do an experiment where somebody of 5 years call and somebody in silk asks the same questions of the same witness in the same tone, and the audience's take on it would be different.
Yes. Yes.
So advocacy has to evolve as you do. Yes.
That's interesting. So perhaps you can get away with a bit more in court when you're younger. Not that we should necessarily try to.
I think it, in terms of how you behave towards witness, that may be right. One of the most famous notes you get when you take silk, there's always somebody who says to you, well done, congratulations, do remember the purpose of leading counsel is to ask leading questions. And I think that sort of thing can be easier when you're senior.
Yes.
Shouldn't be. Maybe they think, well, it doesn't matter very much, so we'll just let it go. Whereas if you're junior, they think maybe you don't know what you've just done.
Yes.
But I think in terms of tearing after somebody and pursuing your enthusiasms, it can be easier as a junior member of the bar. Yeah, as a young junior member of the bar.
So get all the fun out early doors with any pent up.
Yeah. Yeah, you can still have fun.
So your list of practice is actually quite daunting. I did the GDL last year, and there's all my modules. There doesn't seem to be very much that's missed off your list of areas that you currently practice from those modules. So it's a massively broad range of areas. Do you feel that there's any particular areas of practice that require the strongest emphasis on advocacy, or is it equally important across all of those?
I think jury advocacy and civil advocacy are different things.
Right.
I'm actually a huge believer in crossover. I think, I mean, this is heresy, I am aware, but I think that too many people say they specialize in an area of law and not enough barristers say they specialize in advocacy. And I would say that, wouldn't I? Because I've chosen to be broad and shallow. A fairly good description, I'd have thought, generally. But the point of it is that you have to understand what your function as an advocate is, and it's such a broad term that saying I'm an advocate doesn't actually necessarily elucidate very much.
Yeah.
So firstly, there's a huge difference between jury advocacy and judge-only advocacy. High Court judges used to come out onto the Northeastern Circuit, where I principally practice, and the Northern as well. In those places, there was, certainly in those days, a vast amount of PI and family work, but not much other civil work that people were interested in doing. And they would regularly say, I'm not a jury, Mr. X.
Yes.
On the other hand, jury advocacy lets you do two things that are really quite important. The first is explain a complicated concept simply without condescending. And the second is to understand that emotion is important, and that is true of judges as well. It's just they don't necessarily need the same full-on approach.
Yes.
And sometimes they don't like it. I've certainly done a case in the Court of Appeal where the one member of the court who was a criminal specialist spent a huge amount of my peroration staring at the ceiling. And that's because he knew and I knew that what had happened was not really fair, even though the appeal may have lacked merit other than that. I saw him in the street afterwards, and he said, "How did you think it went?" After I'd been thumped, obviously. I said, "You wouldn't even look at me." And he said, "The coving in Court 15 is just fascinating, don't you think?" So judges do feel it, but it's got to be approached differently. And so advocacy is about knowing the audience and knowing what's required. And it's important, I think, in every arena. Now, that is not to say that your performance on your feet is necessarily going to change the result. I mean, if you do criminal work, you're pretty regularly told that you'll do 100 mitigations. In 60% of them, what's going to happen is fixed. Nobody's going to change it.
Yeah.
In 20% of them, you can make a bit of a difference. And in 20%, it makes a major difference.
Yes.
But that isn't the only point of advocacy. Advocacy is also about clients knowing that they've had your best effort.
Yeah.
And the judge knowing that the points have been made and can be relied upon when they come to give a judgment. So when I go in to do a civil trial, and it's all about documents, and it's, you know, the most likely phrase is not "you're lying, aren't you?" Not that that ever really comes in a criminal trial either, but it is much more likely to be "if your lordship would be good enough to go to file 95, page 462. But even then, it's really about doing what the judge wants to help the judge get the information, and doing what you need to do to make sure the information emerges in a way that's supportive of your case. And that's true whether you're citing a document or an authority. And it's incredibly important because, and I really believe this, the rule of law is what stands between any society and ungovernable anarchy. And for that to work, representation has to be competent.
Yes.
And so you have a job to do, which is about presenting a case. It may be a bad case, it may be a good case, and the judge gets it wrong. It may be that you and the judge have differing expectations or differing views of what's good or bad. But it doesn't absolve you from the obligation to do it properly. That's why when it's clear you're going to lose a case, and we've all been in cases where it's been clear from half a day in that you're going to lose, and you've got to plow on the other 6 days. That's why you don't just stand up and walk away.
Yeah.
Tempting though it can be.
If nothing else, it's symbolic to your client, isn't it? It's saying to them that they have had their day in court.
Right, but I don't think that's symbolic. I think it's more than that. It's saying to them, your case has been properly presented, properly explored, and properly urged. Because when they lose, then they say, well, I had a reasonable run at it.
Yes, yeah.
Now, if you don't do that, and this is why I'm so unhappy about litigants in person, if you don't do that, they go away, and it isn't even that they necessarily think my barrister was crap. That's not what we're talking about, but what's in their heads is, if only X,
Yes,
Y, Z, then the result might have been different. Now, the minute you allow a legal system to have that worry as more than a peripheral element of a few cases, you've really undermined the entire thing. That's why being a barrister is genuinely a vocation, and that's why it's genuinely a responsibility. And that, of course, is why when politicians try and pretend it's something else, it's so enormously aggravating.
Do you think that clients will be feeling, and have you had experience of clients feeling more of that, if only, with a lot of this now being online? And is there anything that you can do as an advocate to give them the feeling that they're still getting the very best representation, the best experience, the best day in court that they can, even if it's done through a Zoom call like this?
I think face-to-face is better. I think it's easier to read people if you are there in front of them. I mean, I've found, having tried cases on Zoom, that from the judge's perspective, actually, the court system has the ability to, on the judge's screen, to bring people into the center and push everybody else to the periphery.
Yes.
So that the ability to focus in on the witness so that they loom up on your screen in massive detail. Tip for advocates: do not think that because you're on the screen you don't need to shave. Male advocates. But that ability means that from the judge's perspective, it can make up for the fact that you can't see the whole of the body language. The difficulty I have with it is it's very hard to have a con. It's very hard to have the sorts of conversations you habitually have before and after court at the end of every day in the same way. The technology can be slow and glitchy, and any break on the line means that people end up talking across each other. And my own experience in front of a more than one person tribunal is that when it's 3 or more, it's incredibly difficult to know who is looking at you and who isn't. And in a court, you read that automatically. In the Court of Appeal, there'll be one person looking at you, one person reading the papers or making a note, and the third judge will be focusing like a laser, but probably on the judgment in the next case. I mean, that's slightly unfair, but you take the point. Oh, you've gone. There you are. But in a Zoom meeting with 3 members of the tribunal, they can all appear to be looking at their screens, but in fact, none of them are looking at you, or 2 of them are looking at each other. And that, I find that very difficult, and it manifests in exhaustion.
Yeah.
And I'm 3 hours of that and I'm done for the day.
Yes, yes. Yes, you do tire a lot more quickly, and you've got to pace yourself. And personally, I find speaking slower is even more important. But then you worry that you're not really being followed. If you're trying to be too purposive in what you're saying, you suddenly start to worry about, am I coming across correctly? Are they actually hearing what I'm saying? You get distracted by all of these other things that are going on your screen.
Absolutely. I think it is genuinely difficult. I mean, we've all opted for bookshelves. You know, I ought to say this is a background, because if I were to reveal to you the entirety of my study, firstly, my wife would be humiliated by the fact that she's never made me clear it up in 20 years. And secondly, it would be massively distracting.
Yeah.
And I think that's right. It's harder to focus on just the person on a flat screen. It does weird things to your perception of things. I don't love it. I don't think it's massively inhibiting, but it's suboptimal to me.
Do you think the best advocates in person will still come out as being the best advocates on screen?
That's a really interesting question. No, not necessarily. I think a lot of very good advocacy, when you see somebody at the absolute top of it, they have a personal connection with the other people in the courtroom, which I think is partly to do with physical presence. And so I'm not sure that that's going to happen much on Zoom. No, so I think it's probably tends to flatten the curve.
I guess it links back to that point you were making earlier about knowing your audience as well, and making a connection with your audience.
Right.
Understanding what their needs are and what they're interested in. Do you have any advice for students like myself and others who'll be watching this? How can you create a connection with your judge? Obviously on Zoom it's doubly difficult, but when you're just starting out, when you're the most junior of juniors, how do you make that connection?
I think you can do 3 things. The first is answer the damn question. Yeah, I mean, I've heard, and I have very occasionally done it, senior people say, can we just park that, my lord, and I will get to it. And if you are in the middle of a hugely complex developing argument and you've anticipated the question and you know you've got an answer and you know that you are going towards it, then I think fine. Although even then I'm tempted to say, if I haven't got there in 10 minutes, do feel free to ask it again. In any other circumstances, they've asked because they want to know. And they want to know now. Now, if you ignore the judge bit, okay, you're having a conversation with one of your friends, and they say, well, what about this? In the course of a normal conversation, you'd say, oh, well, the answer is ... You wouldn't say, well, don't ask me that now because I'm getting there. And if you did, they would just say, rude bastard.
Yeah.
That is what they would say. So why should the judge be any different apart from the fact that he won't say that?
Yes.
Probably.
Might mutter it.
Right. Or make a note.
Yes.
Give me a minute. So I think part of it is simple courtesy, but part of it is you want to carry this person with you. And they have engaged. They've said, well, we need to sort out this. So sort it out. And that's the first thing. I think the second thing is watch the pen and watch the expression. Some judges are very expressive. Some are utterly inexpressive. The pen is a clue. If it's, or the fingers nowadays, if it's worth noting, they'll note it.
Yes.
If you've been going for 5 minutes and they haven't made a note, that may be a clue. But I would also say it the other way, and it does take courage, and you've got to work out how you're going to do it with courtesy. But I've made points in a case where I really have, they may be bad points, but they are central to the argument. And the judge is not engaging.
Yeah.
And I do occasionally, and did even as a junior occasionally, pause. And the judge would say, "It's all right, Mr. Myerson." And I would say, "Well, Your Honour hadn't taken a note."
Right, yes.
And this is going to be a pivotal submission. They won't thank you for it, but you're trying to gain attention. And judges are professionals. They may go into, well, they certainly will go into the judge's dining room and talk about you. And if they say that doesn't happen, they're fibbing. But they may well say, cocky little so-and-so. They may well say confrontational. But they will divorce that from the substantive point. I've only come across in my whole career 2 or 3 judges, all of them weak and uncertain of their own ability, and I might say with good cause, who hold it against you for making them take a note of a good point.
Yes. So it's having that little bit of courage.
Right, and remembering your obligation is to the client. I know you've got obligations to the court, of course you have professional obligations, but there is no professional obligation to stroke a judge. There is no professional obligation to assume that because His Honour is not making a note, that means your point is unimportant. That's not the job. And you have to learn a way to do it that both doesn't set you at such odds with the judge that you can't then communicate, but which also grabs their attention. And it isn't always done by being nice.
Yes.
It is always done by being polite, even if the politeness is cold.
Yeah. It's having the tools, those forms of address, etc., that you learn from the very start, comfortably embedded so that you can apply them where necessary and apply your manners and your courtesy and respect to the court in a way which is actually effective, rather than being so worried about everything else and coming across correctly that you actually can't have courage in your convictions when it really matters.
Right, and also about knowing what your key message is.
Yes.
And being prepared to deliver it.
Yes.
I once saw, it was almost, I thought there were going to be fisticuffs. I was sent by my pupil master to watch the late Hubert Dunn, who ended up as a circuit judge. And Ed Lawson, who was my pupil master, said to me, "Go across and watch Dunn, because he's the bravest advocate at the bar today." So off I went. Out of deference, I won't mention the judges in the Court of Appeal, but they were a difficult group. And he stood up and he said, "I've got 9 grounds of appeal," which is really quite a lot.
Yeah.
And they said, not unsurprisingly, "Well, give us your best ground." And he said, ground 1, and he argued it for 5 minutes. I mean, it wasn't massive. And they said, is that your best ground? And he said, ground 2, and then did that. We asked you for your best ground 3.
Yeah.
Anyway, by this time, the man in the middle, who was notoriously irascible, said, we asked you for your best point. Which is it? And received the reply, your lordship is paid £120,000 a year to decide that question. It was just astonishing. And I went back and said to Ed, essentially, this man is my hero. And he said very sensibly, firstly, he is talking on the back of 30 years professional reputation. So you cannot do that. Secondly, it works for him because he genuinely doesn't give a toss.
Yeah.
And that may not be you.
Yeah.
And thirdly, it may be that there are other ways to get to that point, but I agree it's amusing.
Yeah.
And I think that's where you've got to be.
Yes.
You're prepared to do it, fine. But reaching for the flat confrontation, you're not up to this, you're not giving me a fair shout, is not always the best start.
Mm-hmm. It's who you are and what you feel comfortable with, really trying to do. I just want to bring in one of the quotes which I saw from one of the blogs on the pupillage site of Curran's judge saying, if that be the law, Mr. Curran, I shall burn all of my law books. And of course he replied, well, you better read them first, my lord.
Yeah, and it's very much the same thing. Hugely amusing, helpful.
Yes, questionable.
I mean, I think sometimes you've also got to be cautious that you don't give in to your own satisfaction.
Yes, yes.
And I remember Ed in a very, very well-known case where I was his pupil, cross-examining the expert on bloodstains, and the judge clearly playing for the pros, and constantly interfering in the cross-examination. And in the end, Edmund protested in front of the jury and said, we're really not going to be able to get to the end of the cross-examination if I have to keep retreading this ground. And the judge, I think knowing he'd gone too far, said, yes, Mr. Lawson, that's fair enough. You carry on, I won't. And it's clear to everyone he was going to say, I won't interrupt you again. He got as far as I won't. And Ed said, well, with the greatest of respect, your lordship will. And it was massively amusing. And at the end of the day, he felt really good about it. Yes. It was like, right, I've done this. Anyway, that point became quite important in the appeal. And it was the only time in my professional life I've seen counsel try to bribe the shorthand writer, who in those days produced the transcript by hand, to take that little passage out, just so that their lordships wouldn't be troubled by it. So Winston Churchill was the one who said, don't speak when you're angry. If you do, you'll make the best speech you ever regret.
It's like that whole thing now of sending emails and taking your time, not sending one straight away. If you're feeling disgruntled about something, giving it some time before sending it. Usually you never end up sending anything which is remotely similar to it.
Absolutely, yeah, keyboard warriors.
I'd like to move on a little bit, Master Myerson, to your preparation and the process that you go through when you appear in court. The other night we had a sort of pre-discussion for the Rosamond Smith competition, which is coming up in the spring.
Right.
And Master Zoe O'Sullivan said something very interesting to us there. She said that when she's preparing for oral submissions, she will actually learn the start of her submissions so that she's got something which allows her to become comfortable She knows that at that first moment when you stand up in court, she knows that she's got something to say. And then once she's settled into it, it's fine from there. What sort of process do you go through? Because it must be very individual.
Well, I share with her. I don't learn anything by rote, but largely because my experience in student drama taught me I was incapable of doing it. But I absolutely share with her the need to push off firmly.
Yeah.
I spend a lot of time, both before submissions and before cross-examination, thinking of what's the best starting point. Because you need to convey what you're going to say, and you need to grab people's attention. And I also agree with her that if you get the first bit sorted, it often flows very easily.
Yes.
Conversely, if you get it wrong, it can lead to some real nightmare derailments and halting. And because what you don't want is to start with your most contentious point.
Yeah.
If you do that, you'll spend the next hour discussing it with either the judge or the witness. And you won't have any time to develop an argument. But at the same time, you don't want to be utterly anodyne at the beginning. There's got to be a bit of oomph behind it. So I tend to have in my head a very provisional order of points.
Yes.
I certainly know what the first subject is going to be. And then I play around with it as things develop.
Yeah.
So if I'm not going first, that can be quite a long process, and my notebook or my screen will be full of little typings, and then I think, no, that's no good, and I'll type something else, you know, just to prompt myself.
Yeah.
If I'm going first, I normally talk it through with the junior or the solicitor and just try out approaches and see what works.
And will you have separate notes from the skeleton argument?
So the temptation is to make the skeleton into your submission, which is what judges regularly complain about.
Yeah.
And the elephant in the room is that what barristers don't say, but they definitely think, is, well, if I could trust you not just to read the case, because they really do read it, but to think about it, which is not the same exercise, then I could make my skeleton 5 pages long.
Yeah.
So if you look at a lot of skeletons are, I'm doing the thinking for you.
Yes. Yeah.
And what the judges say is, well, I don't need that. I just need the proposition that comes at the end. And what the bar says is, no, if I did that, you would just look at it and go, no, that's not right. I need to, it's like maths when you're a kid, you need to show you're working out.
Yes. Yeah.
And it's the happy medium between those things. So I tend to try, if I'm kicking off a hearing, to abstract the skeleton back, by which I mean stand away from the detailed arguments that are there and try and get the 2 or 3 points the case is really about and on which it really depends, and then introduce it in that way. I try. I'm not pretending this always works or that I always do it properly, actually. If I am second, if I'm responding or I'm defendant, then I've almost always got written on my opponent's skeleton, because I'm still so old-fashioned that pen and paper work better, a complete and lengthy answer to the points that really bother me, but very rarely do I deploy the whole thing. And normally end up saying, well, I've gone through my case, I've got 4 or 5 things I want to say about my learned friend's skeleton, and that's probably culled down from about 20 comments, because they drop away as you see the judge's response to them. You know, you don't have to say everything you ever thought of.
Yes. Yes. And on the flip side of that, will you ever think of something in the time between the skeleton going in and your appearing in court? And how would you bring that in? If it's not in a skeleton argument, how would you go about trying to raise something which perhaps you've suddenly thought of on the drive to the court?
Okay, so my test of have I prepared this case properly is, can I read my opponent's skeleton and think, yeah, got that, yeah.
Yes.
If you've got an argument in the skeleton of your opponent which you have not addressed, then there should only be two alternatives. Either you have not done it properly, or he is or she is barking. And it's a completely mad point. And neither happens very often now. I think at the beginning it is prone to happen more because you just have less experience of things.
Yeah.
If you do think of something, I mean, their professional ethics is very clear. You email your opponent these days and you email the court, but I always you can do them both at the same time, and if time is very short, maybe you would, but I'd always prefer to correspond with my opponent directly first of all.
Yes.
And say, I had a brain freeze, I should have said this, I clearly should. I'm going to ask them if I can develop the point. I'm giving you a heads up about it. If you were going to make a massive row about it, would you be kind enough to let me know? Equally, if you're kind enough to say, well, everyone misses things out occasionally, so let's just let this one go, would you let me know? Because then I can tell them.
Yeah.
And then email the court and say, I've spoken to Mr. or Mrs. X or Ms. X. And although they're not entirely happy, they're on notice that I'm going to make this point, and I apologise for not getting it in advance. But it shouldn't be happening. I mean, I know barristers bore on about preparation all the time, but there is no substitute for it. There really isn't. And anybody, a barrister who tells you they're winging it, if they're any good at all, they're not telling you the truth. That there's a difference between, I've thought of a way to expound the point, of a way to link points together, of a way to develop an argument. Yeah, all of that can come to you on your feet because you get suddenly into the flow and away it goes. But I didn't know anything about this case till I picked it up this morning, and I made these submissions without reading it. I mean, that may be true if they're rubbish and they don't know what they're doing, but otherwise it isn't true. Whatever they tell you. I mean, Gilbert once led me, and he's a man for whom I had enormous affection. I knew he'd read the papers because we'd gone to court together. It didn't stop him because we were sitting right next to the jury. Prosecution are an hour into this very lengthy opening, and he turns around and in a penetrating whisper says, "I'm so glad I haven't opened this brief, dear boy. It gives me a jury's eye view." And they're laughing, but it's a lie. It's a complete lie.
Preparation isn't very glamorous, but behind all of these, whether it's advocacy, any sport, any ability, it's the thing that drives it, isn't it? There's no substitute at all. It links me quite nicely into what we'll make the sort of summary question. What three factors, because of course as barristers love threes, factors do you think, Master Myerson, are most crucial for effective advocacy? If we could start with three things, and if I may perhaps put preparation as one of those.
Well, preparation is one of those. I think that's the first thing. I think the second thing is having the emotional intelligence to feel your tribunal, and understand that they have an emotional response as well as a legal one.
Yes.
They may try and squash it. They may try and exclude it, but it's pointless not to think it's there. So you can't go to the Court of Appeal and say it's very unfair, but you can recognise that there is an unfairness, and that may make the Court of Appeal think, well, hang on a second, is this a sensible result? Was this something that was properly conveyed to the jury? And that means a certain amount of flexibility, including the ability to retreat if you've gone in too hard or put something too high. Do not ever accept the court's invitation to up the stakes. When a judge says to you, are you really putting it like that? It's dollars to donuts that your proper answer is, no, I was a bit over the top on that, my lady, and can I please walk it back now? Because if you do that the first time, everyone just nods and says, okay, over enthusiasm, on we go.
Yes.
If you double down and triple down on it, in the end, you're either stuck there, or the walk home, in the words of the boss, is going to be a long and excruciating walk home.
Yes.
Probably with a judge who wants to kick you every step of the way. Why put yourself through that? So I think that's the second thing, to be able to, that's what the prep gives you, that when you stand up, the arguments are there. You are doing the other bit of the job. You're being the advocate. And I think the third thing is a sense of reality. Every barrister I know, and me certainly, have had the case where we are persuaded by our own brilliant advocacy, only to find that the court doesn't take the same view.
Yes.
And there is a case for really hammering it and pushing it and making the point. But you have to be realistic that there's a difference between the very rare case where you say to yourself, I think this is wrong, and the much more common case where you say, all right, I don't like the result, but it is within the reasonable scale of results and I can see where it got there. And you can't react to the one like you react to the other.
Yeah.
So I think you have to take the real world with you.
Not get lost in your own genius and brilliance as
Yeah. The trouble with genius and brilliance is that, we all know that if you put the sun in a mirror, it grows brighter. But if you're looking at it through the window, that doesn't necessarily work. It's a useful analogy, I feel.
Back to reality, perhaps.
Yeah.
Excellent. Well, Master Myerson, thank you so much. I think that's been a really fascinating discussion. I hope all our viewers find it as interesting as I have. It's been really enjoyable to pick your brain on some of these topics. And of course, just finally for everybody, recommend having a look at the website, pupilageandhowtogetit.com, and there's some really interesting information up there. Perhaps we might even have another session with the MTSA talking about that, because I think we could have a whole other discussion about the topics on there. But for now, thank you so much. It's been a great pleasure to talk to you.
Thank you very much. And thank you for asking me. I hope it's been helpful.
Thank you.